Today's webinar is the state of ADA app and web accessibility lawsuits. I'm excited to say that today's session is eligible for 1 continuing accessibility education credit for those who are certified professionals in accessibility core competencies and certified professional in web accessibility by the International Association of Accessibility Professionals. So if we have some accessibility professionals, IAAP members with us today, welcome. So I'm going to go ahead and hand off the presentation now to our first speaker, Jason Taylor, who is the Chief Strategist here at UsableNet.
Thank you, Bethany. And I'd like to welcome Kristina Launey from Seyfarth Shore, who's going to essentially be our expert on this journey. My role essentially at UsableNet is broad, but one of the things I do is oversee the collecting and reporting of digital ADA, so that's app and web related lawsuits, and try to produce a report that helps the industry in general to track that. Kristina, maybe you could give us like just 2 minutes of your background and also the types of services and experience of Seyfarth Shore.
Yeah, absolutely. Thanks, Jason. Hi, everyone. As Jason noted, I'm a partner with Seyfarth. I specialize in disability access as well as other non-discrimination and employment laws on the employment side of things, separate from the public access side of things. And at Seyfarth here, we have a team called our Disability Access Team with partners in every office. One of our partners, Minbu, who many of you know, was at the DOJ. And so we have a unique perspective nationwide into the impact of web accessibility lawsuits on our various clients. And we, like Jason and UsableNet, do follow all the trends in the law and the lawsuit filings. And so we're excited to be here speaking on this with him today.
Thank you, Kristina. So quick overview of what we're going to try to achieve. We're going to be pulling from the reports and some of the data that we've got, really just sort of like give a framework of what we see are the major trends. What I'm going to ask Kristina to do is essentially give us the legal color behind that, particularly you know, how we've got here, but also maybe looking ahead to 2024 and see if there's any significant changes or not in the particular spaces. We're going to end with trying to give you at least a simple sort of takeaway around what we feel could be things that you could do immediately in the accessibility and the sort of risk litigation space. Essentially, you know, as many people have probably heard before, you know, that the best way to defend a lawsuit is not get a lawsuit. So essentially, we want to give you some sort of roadmap to potentially make sure that you're trying to reduce your risk, but at the same time really increase the accessibility of your websites and apps. Quickly on the methodology of the data that you're going to find that we use here. We produce a report twice a year. Essentially what our team does is track all ADA related federal web lawsuits that are filed. Important note to that is that many of the ADA lawsuits that are filed are for a physical property. We filter those out and we only track the ones where the subject matter is someone claiming inaccessibility to a digital property, whether that be a website, an app, or some type of other digital property. We also look to follow cases which are filed for the same reason at state level. You're going to hear particularly in New York and California are the most active, but essentially in those cases as well, primarily the ADA is sort of claimed as the main act that has basically been used to bring those cases. So what we try to do is sort of track those and bring you trends around those areas for people who are operating and maintaining websites. So if we pull out some of the numbers, and I'll get Kristina to start giving us input on this. Last year, 2023, we saw in the region of 4,600 cases. That's totally across the state courts that we're tracking and the federal courts that we're tracking. And that's a slight increase in total, but it's actually a decrease at the federal level and an increase at the state level, particularly in California and New York. So I just wanted to maybe Kristina to give us a little bit of legal clarity of why we've seen that trend potentially increase at the state level and federal cases have dropped slightly.
Yeah, thanks, Jason. It is a really interesting phenomenon to watch over the years, both since UsableNet has been tracking these, and to Jason's point, at Seyfarth, you may all know, we publish a blog every year where we also publish the data for all Title III cases, and our blog on that should come out probably next week, and that means including, physical accessibility, other sorts of effective communication cases, service animals, et cetera, not just web accessibility. And we've seen a decrease last year and a decrease this year in the overall filings in federal courts. Now, that doesn't mean lawsuits are decreasing overall, right? It means that in part, some plaintiffs are filing more in state courts, as Jason, UsableNet's data here shows. And it also doesn't take into account the fact that we still see hundreds and hundreds and hundreds of demand letters every year that never actually manifest into a lawsuit. Part of the reason, though, that we have seen some of these numbers shift is, you really need to look at it state by state and what's going on in the different states. And if you, attend any of the deep dive legal presentations on this, those numbers depend on the way the courts are ruling on some of the digital accessibility issues. And when a federal court or federal courts on the whole in a certain state are either issuing more decisions that are friendly to defendants, or they're being stricter on plaintiffs. Like last year, we saw in New York a couple of decisions where the judges were pretty critical of the complaints that the plaintiffs were filing. We do start to see the lawsuit shift a little more to be filing in state courts rather than federal courts. So we did see that quite a bit actually in New York. We saw more and more New York lawsuits filed in state courts rather than the federal courts. We saw a new attorney plus, more veteran plaintiff's attorney in New York start filing cases in New Jersey state courts, whereas we hadn't seen really any New Jersey filings before. And then we also saw some plaintiffs that had filed lots and lots of cases in federal courts in California move and start filing more in state courts. Again, mostly looking for more friendly venue, or, courts that they think are going to be more likely to rule in their favor, either because of the state of the law or because of the way the judges are going. Or it also could be in some part because it can sometimes be more expensive to pay the initial filing fees in federal courts than it can in state courts. So a variety of reasons, but we have seen a bit of this trend here.
Thank you so much, Kristina. I thought the next two slides sort of bring that big number down into a very small window, which is like a week. So, the big number is 4,600 a year sounds big. It is big. But if we bring down to the week, I think it helps paint another picture around this particular space. So every week, there's 80 to 100 lawsuits that are filed each week. I think it's important, we talked about, and I think we're going to talk a little bit more about New York is really the hotbed right now. And I might get Kristina to talk a little bit more on the next slide when we talk about the different states and which ones are the most, about why that is in terms of cases and again, as she said, in terms of judges' attitude. But I think the important thing here, and Kristina will talk about this frame is of those 80 to 100 lawsuits every week, 84% of them are sort of represented by 10 plaintiff firms and around 25 plaintiffs. So the picture here that you need to understand is this is not 4,500 individuals that have gone out, struggled with a website, struggled with a native app, and then gone and found a law firm to represent them to try to get, try to claim and get remedy of fixing that website. It's a very focused, aggressive group of plaintiff firms, which essentially would represent themselves as aggressive advocates, where defense firms maybe describe them as slightly different. So I thought maybe, Kristina, you could sort of give us that sort of history. Is that something that's been like that ever since you started seeing these lawsuits? And I've been tracking them for 5 years. You've probably been involved in them longer. Is that a trend that you see continuing? Do you see that number of plaintiff firms and plaintiffs increasing? What would your view be on that?
Oh, absolutely. The number of plaintiff firms and plaintiffs who are filing these lawsuits has increased over the years. When I first started practicing in website accessibility, and I think I had my first case in 2012, there was the Target case in, I want to say 06, 07, if I remember correctly. And then there wasn't a whole lot, it really wasn't a thing yet. And, by the fact that at our firm, on our data blogs that we issue, we started tracking all filings in 2012, but we didn't start tracking website accessibility filings until I think about 5 years ago, 2017, 2018, which tells you it wasn't really on our radar that there were huge quantities of lawsuits being filed in this specific area of Title III of the ADA until relatively recently. Back when I first started doing digital accessibility, it was really more the advocacy actions, brought by the Lainey Feingolds of the world, disability rights advocates, trying to make a big impact with their legal actions, and often, asking defendants to engage in structured negotiations rather than actually filing a lawsuit. And, there were 1 or 2 firms that started filing the lawsuits after that. But, with this gray area that we've been in for so long, where we haven't had regulations like we have in the physical accessibility space that are telling businesses how their websites need to be coded, what standard the website has to meet to be considered accessible in violation of the ADA, and the fact that it's relatively easy to try to access a website and be denied access. We've seen more and more and more plaintiffs' attorneys getting in on the mix every single year, and the new ones who enter the area almost, to a T these days, are filing complaints that are almost verbatim what we see other firms filing.
Yeah, it's interesting. I mean, we've seen this year, new plaintiff firms enter that sort of top 10 list, and they enter that top 10 list means that they're quite, they're quite active. They're not representing 1 or 2. They really are targeting more. The other thing that I would like to sort of bring to attention, I think you sort of you sort of lent to this in that last comment, like the typical claim that we see has a familiarity about it. Whether it comes from plaintiff A, plaintiff B, there's a structure to it. In some cases, a very close structure between one and the next. You could argue that's because a lot of websites, similar websites, are sued, so they use a very similar structure. Our typical understanding and what we see is a claim is brought by a plaintiff who typically uses an assistive technology like a screen reader. That's about 95% of the cases. Some of the other cases are brought by people who are deaf. But the other major aspect is that they would list certain things in that claim to basically back up their approach to saying, hey, this plaintiff has been denied access, and that could include, and most of the times it includes, some type of description about the type of issues that the person had. There might be some screenshots that capture those issues. There'll typically be a list of accessibility issues found by some type of automatic scan that they basically run on the website, and they put that into the lawsuit. They might list other things that they found problems with. For example, if someone was using an accessibility widget which didn't work very well with the screen reader, they might put that feature in as an additional evidence of discrimination. I think the point here is you've talked about it, Lainey. These are quite common. They are very similar. I actually think it'd be very useful for people to understand what happens to most of these cases. 4,500 cases is a lot. We only see 2 or 3 legal cases talked about on a yearly basis. What happens in general to a case that's brought? What is the outcome typically that is being looked at by the plaintiff side, and how do you go about supporting clients, getting people through that as quickly and painlessly as possible?
I think most of our clients would say it's never painless. Nobody ever likes to be having to deal with a lawsuit, but I think that the easy answer to your question, which is always somewhat distasteful, is the vast majority of the lawsuits that are filed, to your point about seeing very few court decisions on them, is the vast majority settle, and they settle very, very quickly. And a large reason for that is most of the attorneys that are filing these lawsuits, you can't file that many lawsuits and litigate them all. So they're looking to settle them also. And the value proposition is often that it's less expensive to pay to settle at a very early stage before you run up attorney's fees on either side, rather than to litigate it. Even if you feel like your website is in pretty good shape, because there isn't a clear standard for, does the website have to be 100% perfect? Or, is there a substantial conformance standard? What does that mean? All of those questions that we don't have clear answers from the courts to, so you would have to litigate, which can be very expensive.
Right.
And so that's what happens to most of these lawsuits.
And I think it's worth people knowing, if they're new to this, a lot of times people hear lawsuits and they hear like multi-million-dollar damages, right? That isn't the case with an ADA case, correct, Kristina? ADA cases are not that sort of world, for example.
99% of the time, but if you look at the settlement in the Target case, that was in the millions. It was a class action. We really haven't seen anything like that since then, and that was, again, at the very beginning of web accessibility litigation, so it was kind of groundbreaking. We do see a lot of lawsuits pled as a class action. Very, very, very few, like next to none, either proceed as a class action or settle as a class action. It's not none, but it's close to none. The vast majority are single plaintiff cases, so a single individual suing a business, or they sue on behalf of a class, but they end up just resolving it on a single plaintiff basis. And so if you settle quickly, you're just, paying for a small amount of attorney's fees, relatively so, and potentially, if you're in a state that allows for recovery of damages to the plaintiff. It's only if you litigate the case for a long time do you end up paying a larger settlement, or are you exposed to potentially a larger judgment in the vast majority of these cases, because if you're sued in any state where there aren't damages available, the only recovery available is an order that you fix whatever the barriers are on the website and attorney's fees. And even if you litigate a case all the way through, the attorney's fees are in a couple $100,000 and not in the millions. And damages in the vast majority of these cases, even if you're in a state that allows for recovery of damages, are going to be relatively minimal, in the 4 to 5 figure range. But then you also have a case, like you look at the Domino's case and how long that case was litigated, and then the settlement that came as a result, those numbers are likely bigger there. They're still in the millions, but they are bigger because they litigated for quite a while before they settled.
Yeah, I think you've made a couple of points there, which I'll just highlight and summarize. When you receive a lawsuit, basically the clock starts ticking on both sides in terms of costs for lawyers, because there's no real clarity about how you handle these in court quickly. If you want to defend yourself, you're going to spend money, which means also the plaintiff firms can rack up their bills. So practically, it's good to settle quickly, and that sort of understanding that there's a sort of I don't like to use the word playbook, but there is a sort of playbook on the plaintiff side, as you said, that it's a volume activity. They've got an idea of what they want to achieve in every lawsuit. They want to get something from a monetary point of view, and they want to get remedy, meaning they want to get the website fixed, right?
Usually.
I mean, we can argue how genuine they are about the second component. But I think that also emphasizes why, if people are on this call, what the value of Kristina and a Seyfarth bring to the table. They know every plaintiff. They sort of know what these plaintiffs will bring to the first meeting, what you should probably bring to the first meeting, and really what their goals are, and help you navigate those goals. And again, I know none of this is painless, but as painless as possible, and feeling like you've got someone who's been there before hundreds of times, at the table with the same person, by your side. And that's my sort of reason why I try to make sure that I do these events with someone who's got that type of level of experience.
Yeah, and to add on to that real quickly, Jason, I appreciate you saying that, but the other practical aspect to that is that, most of our clients or companies that come to us, they've been sued and they're very indignant, and I mean, I've even had lots of clients who, have huge involvement in disability rights organizations, who might have themselves or a family member who is disabled, and they've put a ton of time and effort into either making the website accessible or doing other things. And so they're very upset and they want to fight it. And it's really important to have an attorney right out of the gate that understands the law very well and understands, to Jason's point, all of the attorneys and plaintiffs that file these cases, so that they can give you the practical advice and say, sure, you can fight if you want, but here's how that's going to play out. Or you could seek resolution, and that's how that would play out. And so let's make an informed decision right out of the gate before you spend a bunch of money.
Great points. Thank you. So back into some of the numbers coming from 2023, and again, maybe opened up just to get you to talk a little bit about a more legal side, right? We see that lawsuits are filed heavily in New York, a lot in California, and a lot in Florida. And you've talked a little bit about that, about why those are. But I think the first question, just to emphasize, is, well, if we're not based there, are we okay? Like if we're based in Philadelphia or if we're based in Ohio, should we not worry so much about these lawsuits?
Well, the answer to that can vary depending on the extent of your contacts in the jurisdiction, and that becomes, a legal question. But on the whole, to answer your direct question, no, you should not worry. Stated otherwise, yes, you should worry. If you are a business that has a website and you are trying to sell your products, anywhere in the country, for example, and you would sell and you would ship to customers in a certain state, then while there might be arguments available to you, you can't just pass it off and say, oh, we're based in Maine, so we don't need to worry about making sure we comply with the laws of every other state. That's just not true. You really should watch where you are selling, where you are targeting customers. And, and this isn't just even web accessibility law, this extends to other laws of those states as well to make sure you're complying with them. The same argument sometimes goes for if you are a web-only business. And as those of you who follow the law know, the law varies on that point depending on which jurisdiction you're in. So we do have some businesses sometimes say, well, I'm a web-only business, so I don't need to worry about, certain, I don't need to worry about the ADA applying to me because I don't have a nexus to a physical place of business. And the answer to that question is, well, it really depends on which state you are sued in. So you do need to pay attention to where you are selling, where you have a presence, and what the state of the law is across the country related to that.
Yeah, I mean, these are good points as well. The whole idea, and I just wanted to check, that goes for federally filed cases and state cases, right? So, for example, if I was a company that had and was selling in New York State, I could be potentially have a lawsuit in New York State court, or I have to
Correct.
be based in New York State. So anywhere, it doesn't matter. If I do business, I can be sued.
Yes, and like I said, that might not be an absolute statement.
Yeah, I understand.
But on the
Yeah.
whole, you can't assume that you can't be sued and that you would not be subject to jurisdiction there. It is certainly possible that you could.
Yeah, and I would give people a practical thing, right? Plaintiffs go in front of judges and say, hey, this company sells in New York State and my client couldn't do something on that website and couldn't buy something, they're being discriminated against. That's essentially a very short version of the argument, right? But if a judge says, yeah, you're right, I'll let this case go on, essentially that means that now legal fees are going to be quite expensive, and the plaintiff firm says, hey, see, the judge says we can now litigate this and it's going to be very expensive. I'm assuming that's sort of why you can make that case. It is quite practical. If you believe in that everyone should have access, it's probably an easy case to make in front of certain judges. As you say, certain judges look at it differently.
Right, exactly. I mean, and it's different arguments though, right? There is the accessibility argument and there's the jurisdiction argument. Can the court even hear this case? But I think to one of the points you made there, that if you just think, oh, I only need to worry about certain states and not others, you can still get sued anywhere, and you might have to file a motion telling the court, hey, we shouldn't be allowed to be sued in this court, and that's going to cost you money. And the firm might find a plaintiff in a different state and then just go sue you there as well.
So take notice, and we'll get to a point where we say, make sure your website is as accessible as possible. And that's really your biggest defense. I think the other thing that we wanted to pull out here from the numbers, and I think you had some very good points on this, is that we see e-commerce being the number one. It's sort of the biggest, but any type of company gets sued, correct, Kristina?
Oh, absolutely. Yeah. So, and Jason and I talked about this in our pre-meeting before this webinar, that I think the e-commerce dub can be a little broad there, right? Because there's so many different types of businesses that maybe do e-commerce, and e-commerce could also suggest that it could be really web-only businesses, as well as retailers, for example, that may have a physical location. And as I just mentioned, there are some nuances in the law there and in different states and federal jurisdictions between web-only businesses and businesses that have a physical nexus. On the whole, we probably see the greatest number of lawsuits being filed against retailers. Now, that's really, I believe, and Jason might disagree, but I believe that's really just a numbers game, that there are so many retailers out there that, clearly we're going to see more lawsuits on the whole against retailers because of the number of potential retailers that could be sued. That does not mean that if you're not a retailer, you're not going to be sued, because we see lawsuits against financial services, insurance companies, hospitality companies, really across the board. If you are a business that provides any sort of good or service to the public, then you might have arguments that the ADA does not apply, and those arguments might be winners, but you still would potentially be a target of a lawsuit.
Yeah, and I mean, to sort of build on what you said, I think you said something else before, right? So one is volume, easy to find lots of retailers. I think the second is it's easy to visit them, which is, you made that point. You know, you need someone to say, hey, I went and tried to do something, right? And it's easy to visit those stores. I also think from a technical point of view, you know, e-commerce has complexity. You have to, you know, put things in the cart. You have to choose colors. You have to do. There's many things that can be done wrong, quicker and easier on an e-commerce site than, let's say, a simple content site. So there's a lot more for the plaintiffs to use there in terms of from a sort of a claiming of barriers. And also those websites change a lot, right? So again, it's hard to keep up all the time. And then the final item, which is more of a legal thing, which I recognize I probably stepping outside of my boundary, is I believe it's easy to make a case that I needed a piece of furniture, and I went to 10 furniture stores, and all of them prevented me from buying furniture, so I can sue 10 furniture stores. I think it's a lot harder to do in other sectors, but it allows you to generate that volume and generate the stand-in that says, hey, this one person has just sued 10 furniture stores.
Potentially, yes. I don't know that it makes it, you know,
you can
harder.
You can tell who's the lawyer on the call. I
Right,
made a
but I
strong
mean,
statement, and Kristina's like, maybe.
right. I've seen some very creative stuff over the years. So let's put it that way.
So, I mean, moving on from the industry, I think this number sort of needs to be explained as well. You know, of the lawsuits we saw this year, 4,600, 25% of those were companies that got sued for the second time. Now, a lot of people might be thinking, how do I get sued for a second time if I've already been sued and I've already settled and I've already said I'm going to fix the website? How do companies get sued for the second time? And what would you do about it to try to minimize your risk of being sued for a second time if you've just received a lawsuit?
So yeah, this is a really tough one. And, you know, I always joke that in this area of the law, attorneys get their titles of counselor more so than probably any other, because we so often have clients who say to us, you know, how is this even possible? You know, they're just frustrated and dismayed. And again, especially if they're trying to do the right thing and provide access to individuals with disabilities. And the best thing to do, you know, back to the slide a little while ago about, you know, what do you do when a lawsuit, you know, lands on your desk? You want to call an attorney who knows what they're talking about. And you also want to make sure that you're thinking about, okay, how do we get this legal action done and over with, so that's not hanging over our heads? But how do we also address the substance of this lawsuit, which is the allegation that we are denying access to individuals with disabilities because we are not effectively communicating with them through our website. And so you want to look at the substance of that. And if you don't start addressing that right away as well, you're going to be at risk of another lawsuit or more lawsuits or demand letters, both while that first lawsuit is pending and potentially after that lawsuit ends. And so, you know, thinking about other alternative means of effective communication, thinking about how do you make the website more accessible so that it's usable to individuals with disabilities, are things that you want to start thinking about right away. And then also making sure that you understand that if you enter into a settlement agreement to resolve this lawsuit, that's not going to insulate you from other lawsuits coming along, because every individual, you know, I always think, you know, it's very easy to think about the analogy of if you have a store that has steps and you have one plaintiff come to your store in a wheelchair and say, I can't get into your store, and you say, okay, fine, we'll pay you damages for having encountered this, and we'll install a ramp, but you don't install a ramp, and a different person in a wheelchair comes along, they're entitled under the ADA to sue you as well, and would get their damages and attorney's fees until you install that ramp. And that's, really the same sort of concept that would apply here as well.
Yeah, I always love tying it back to the more traditional physical one. I think it helps people really sort of grasp the
Right.
the sort of legal, what the law's trying to do, and also what the plaintiffs are using to their advantage. So actually, that brings us on to, you said, hey, let's, fix this as quickly as you can. Try to make sure you don't get a second lawsuit. One of the things that we see out there a lot, if people are sort of in this space or looking for solutions, is they're going to be sort of marketed towards potentially like a reasonably affordable solutions called accessibility widgets or overlays, which are automatic, which are basically using the magic of AI in their sort of marketing speak. To basically be a solution for that obviously sounds like a great solution. From your perspective or sort of history, are you seeing that these widgets are helping prevent lawsuits? From our data, we don't see it, but I always prefer to see like the real world in terms of what you think is an approach that you think is gonna stop that second lawsuit or even stop the first one.
Yeah, the widget debate is, some real hot water, right? And I always try to be so careful wading into it because, anybody who's in the digital accessibility industry who's on this call knows that there's a pretty raging debate going on between the companies that provide those widgets and the more traditional digital accessibility experts. I do agree with you, Jason, that using a widget absolutely does not insulate you from getting sued. And in fact, we have seen some lawsuits where the complainants, including some advocacy group complainants that we've seen, say that the widget actually made things worse, that the widget interfered with the screen reading technology and made it more difficult for people who had vision-related disabilities, who are blind and use a screen reader, for example, to use the website. Seeing though that, I have had some clients who have said, yes, we understand that just putting a widget on our site is not going to make it completely accessible. And granted, this is a very blanket statement, right? Because the widgets are of different qualities and functionalities, and some are better than others. And some you can apply a widget and then also fix some underlying code as well. But on the whole, just putting a widget on there is not going to make the website fully accessible. And there's, other, dangers to it as the website changes as well. But I do have some clients who have used them and said, we haven't gotten sued since. And I saw we did have a question come in about what scanning tools should you use. And so I think that, and this is something Jason could probably speak to better than I, but some of the widgets will fix some of the most common barriers that some of these tools that some of the plaintiffs' attorneys use as their initial, scan to see if the website has a lot of issues that might make you an easy target for a lawsuit. So from that perspective, they might mitigate some risk, but they could also increase risk as well from what we've seen in some of the lawsuits.
Yeah, I'd say it's a mixed bag. And just from our sort of practical approach, what we do just to understand the methodology is when a lawsuit is filed, we go to that website. If that website has a widget on it, we reference it. That's where these numbers come from, where, last year, 700 of those lawsuits, when we went to their websites, they had a widget on them. So, our point of view is it seems like the plaintiffs are ignoring that. I don't know if it's coming, like, as you said, maybe some of them find it useful to maybe add an additional item on the lawsuit. But I'm pretty sure I've never seen a settlement that basically says, hey, to remedy this site, go buy a widget. That doesn't seem to be a settlement that I've ever seen. So
No.
I would imagine that most settlements sort of talk about the WCAG 2.1 AA as the de facto evidence that you've remediated the site. So I'm assuming that's what you typically would direct people to do if they've written that in their settlement.
Well, I mean, historically, yes. I mean, I say yes, and historically that came about because, the people who originally were the experts on how to make a website as accessible as possible would say that you need to make sure you build accessibility into the code because, websites are dynamic. And as you make changes to the website, if you've already built accessibility into the code, it's much easier to continue to change the code, but keep the accessibility built in. And that would be coding it according to the WCAG guidelines. And so, historically, that is what the digital accessibility experts always said. And accordingly, that's what's built into the early settlement agreements from the advocates that brought actions from the DOJ when it was very active in bringing enforcement actions. And then for the couple of courts that have ruled on the issue, the courts have pointed to the WCAG as a standard that, if it is followed, would make an accessible website. And so, with that sort of historical body of authority, without having DOJ regulations saying this is what you have to do, that's what everybody continues to look at.
Great. It's great history, because I think it's important for people to understand where these things start and how they keep manifesting themselves. I think lastly, we wanted to go through best practices, and this is actually going to touch on a couple of things that we've already talked about. So, how do you make sure you limit the risk as much as possible? And I think we would agree on this. Do as much as you can to make your website accessible. There's a number of ways to do that. That's, in some cases, that's a long journey. That it's not just a project, but there are places you can start where you can increase the accessibility of your website, and I feel reduce your risk against some of these lawsuits. I think you've mentioned, or mitigate the risk. One of those is, as you indicated, right? Most of these plaintiff firms are using some type of scanning tool to find a list of easy to find things which they can put into the lawsuit. We have a free service that anybody can use, and they can test the page. They can test as many pages as they want. You'll get a report, and we'll indicate where we think are the rules that the things that we can automatically detect for you, right? There's a lot more that you should do, but I'll tell you what I like about these types of reports, and I think you've touched on this already. Because they're sort of high visibility, the good news about these reports is most of them can be fixed quite quickly. That's why the widgets can fix some of these, because the fixes are not very complicated. So if you get this report and you send it to your web designer, whoever your web designer is, internal team, someone you pay to run your website, or someone you pay to build your website, hey, can you fix these automatic issues that I found on the website? That will not be a heavy burden for them. The second thing
depends on how large your website is, yes, or how complex.
But in general, my technical observation is, if a widget can fix it, a dev person, an average web designer can fix it just as quickly, right? So
yes.
They're not doing anything magic. But and my point is always, go to the source where you spend your money. They are your expert. They built your house. They built your website. They should be aware of this, and you should either make sure that they feel responsible for it, or make sure, and I've got an item here, make sure next time you sign a contract, or you sign an extension to a contract, that you're trying to push this down their stream rather than something that you're the only person aware of. So there are no clauses you can put in your contract with your web agency to remove your responsibility, but you can make sure that they're taking as much care as possible, because you're forcing it in part of the procurement or part of the contract.
Now, let me
you
put
go,
one quick
Kristina.
caveat on that first point there, Jason. So you say
Yep.
start by testing your site. So let's not forget that, you know, people are launching new sites all the time. So the start by testing your site is, you know, you have an existing site and you get a lawsuit and you're trying to figure out, okay, do I have issues on the site? How do I, you know, fix them quickly to mitigate risk as quickly as possible? But if you're building a new website, making sure that you're building accessibility in, because it's a lot less expensive to do it on the front end than on the back end, and doing QA testing while you're building the site is going to be, you know, a really good point. It's always painful when I have a client that gets sued and they just built a brand new site. Yeah.
I mean, I'll go back to your physical analogies, right? And to get people to just, you know, hopefully instantly understand what you're talking about there, right? You build a house, you put windows in, you put doors in, you put hallways in, you put light switches in. And then you find out that those windows have to be a certain size, the doors have to be a certain width, the hallway has to be a certain width, and the light switches have to be in a certain position. If you did it in the right order to start with, you didn't have to change the house at all. If you didn't take notice of those requirements when you built the house, you're going to have to rip all the windows out, all the doors out, all the light switches out, right? That is the analogy that you're talking about there, and wholeheartedly. You know, if you're building a website and you're following the rules, you're not going to add much to the weight of the project as long as you're following the right rules. So I totally agree with you there. You know, the unfortunate nature is that there's, you know, in the e-commerce world, for example, there's 1.6 million current e-commerce websites which have been built, and most of them have not followed the guidelines. So most of those are exposed and can be brought down in exposure by what I class as doing what the plaintiff firms do, which is the second point I have, which is find someone who you can ask to use your site who is blind. Most of these plaintiffs are blind. You should make sure that your website can be used by someone who's blind and got a screen reader. That will give you a sense of real confidence that your website can be used. Or it will provide you with very meaningful feedback that I believe that your organization will act upon, because real person tried to do the things you expect them to do and they couldn't do it, and they can help you understand what problems they have. And that's a very meaningful way to engage technical people, because I've always found that technical people want to solve problems. And if they see a problem, they see someone struggling, that's a very strong catalyst for change in an organization. I wanted to leave some time. We've got 10 minutes left. I'm going to leave this up, but essentially I talk about, you know, public facing digital accessibility, you know, user tests for people with disabilities, test and find the easy stuff, get that stuff fixed, and think about contracts, think about who you're paying money to and making sure that they're taking the best possible care with your digital property as you need them to in this particular space.
Yeah, and let me just do one little asterisk on your fifth point there, the create and publish an accessibility statement.
Oh yeah, sure.
We get asked a lot because so many lawsuits are filed these days where in the lawsuit they say, you don't have an accessibility statement, you violated the law there. There is no law that requires you to have an accessibility statement. It's considered a best practice so that individuals with disabilities have an easy way to find your contact information, to contact you and get the effective communication that is ultimately the obligation under the ADA. The obligation, you know, is not necessarily to have a perfectly accessible website. It's to effectively communicate with individuals with disabilities. So it is a very, you know, it's a best practice. It's a good risk mitigation measure. It's good client service. But in addition to that, and perhaps even more importantly, we always recommend that companies have an internal accessibility policy and procedure that the company's teams know how to follow to make sure that they construct and maintain the website so it is accessible and that they're interacting with individuals with disabilities appropriately to help them. And those are two components that were often built into DOJ settlements as well.
Yeah, I'd concur there. Like, you know, great to have an accessibility policy, a statement on the website. The policy helps, garner sort of decision maker input and sort of commitment organizational wise. And if you do have an ability for people on your website to contact you and say you've got a problem, make sure that the people who receive those emails or calls know what to do, customer service in particular, right? So yeah, I really appreciate you calling that one out. Bethany, I think, is that the final slide, or because I think we have 10 minutes and I'm assuming you might come back on and guide us through some of the questions.
So Linda asked, like stores under renovation who put a sign up to alert customers to potential hazards, can a caption on the web page stating update in process to give time to correct accounts add a buffer to these lawsuits?
No.
Okay.
That's the easy answer to that question. I mean, it goes to the point that Jason and I spoke about earlier, that the fact that, if you have steps up to your store and you say ramp in progress, somebody still can't get into your store, so you still need to have some other means of effectively communicating with folks in the meantime.
Oh, great point. Love that. Okay. So Kristina, I think this is a question that you will understand. I don't, because I'm not a lawyer, but can you provide an update on the U.S. Supreme Court taking up the case regarding standing?
Yeah, so I think they're talking about the lawfare case, and essentially the Supreme Court didn't answer the question, so we're still waiting for additional clarity from different jurisdictions. Like in California, we had a case that was pending that was put on hold pending the court's decision in the Atchison v. Lawfare case, and since the Supreme Court didn't rule on the issue, we are still in the status quo as to what the uncertain state of the law was. If you want to read about it in detail, looking at the amount of time we have left here, you can go to our blog, adatitle3.com, and we have a more detailed discussion of what the court discussed in oral argument and what the court held as well.
Yeah, and I'd also like just to pull out a point to Seyfarth and Kristina as an amazing resource. They do blogs on a regular basis on nearly all of this stuff, and I always get a lot of benefit from reading those.
Thank you.
So I think this is a question for you, Kristina, or someone said that they read development agencies could be held responsible alongside brands. Have you read or what's your experience with that?
Yeah, so California had a bill pending in the 2023 year of the 2023-24 legislative session that would have imposed a web accessibility requirement for websites in California, business websites in California, and it would have extended responsibility for making sure that websites are accessible to the developers of the website as well, which is beyond where the law presently goes. That bill was put on ice last year. We expect it to resurface this year, but it was put on ice because the language of it was raised as being not practical and not palatable to a lot of the stakeholders. So we will expect to see quite a bit of revision to it this year. Whether that provision or some form of that provision remains in it remains to be seen. But if it did, that would be quite a significant development, because that is far beyond what the present law would require.
Okay, great. We have a question on best practices. Is it a good idea to have a staff customer service phone line or a chat box that can help a customer place an order on an e-commerce site?
Absolutely. So that goes to the effective communication obligation under Title III of the ADA, which is what is where the entire requirement to have potentially an accessible website comes from. Without the effective communication obligation, we don't have a whole lot in the way of website accessibility right now. And if there have been courts that have addressed the issue of, if you have an alternative means of effective communication, like a telephone customer service line, would that comply with your obligation under the ADA, even in the absence of an accessible website? And the courts have held that it's a very fact-specific inquiry. Now, if you have the telephone line, but somebody can get service immediately via the website, but they have to wait hours on the telephone, that's not going to be considered alternative effective communication. So if you have that telephone line, the chat, you want to try to make sure that these services provided via that method are as timely and as effective as if somebody were using the website. But even absent that, if that's just not possible with your business realities, as a practical matter, if somebody can't use the website and they call you and somebody is able to help them, do what they're trying to do on the website quickly, then they're going to be less likely to file a lawsuit just as a matter of good customer service. Now, we also see some businesses that have the telephone line, or they have the chat or an email box, and it's not monitored, or the people aren't trained properly to understand that when somebody says, hey, I'm not able to use the website with my screen reader, and the customer service person doesn't know what a screen reader is, then it's kind of counterproductive in those situations.
That will end the webinar today.